I'm Robert Swafford. I'm a lawyer and trial consultant in Austin, Texas. And today I want to talk with you about preparing for a deposition. There are three things that I want to talk about. The first thing is the 3 rules of preparing for a deposition. The second thing is the purpose behind a deposition. And the third thing I'm going to talk with you about is applying the 3 rules to preparing for a deposition in light of what the purpose of a deposition is. So let's talk about those first 3 rules. The first rule is tell the truth. The second rule is telling the truth does not mean telling everything you know. And finally, the third rule is telling the truth is not telling everything you think. So I want to talk with you about what the purpose of a deposition is. There are many purposes of a deposition, but if you look at the rules, what the rule says a deposition for is to acquire information that could lead to the discovery of relevant information for your case. So essentially the way trials used to be tried was what they would call trial by ambush. So you would bring your witnesses to court, the other side would bring their witnesses and evidence to court, and then everybody would put it on, and then we would see how it all came out. And the courts decided that maybe that wasn't the best way to try a case. And we designed a series of rules, and these rules are called discovery rules, that allow you to find out the information that the other side has. And one of those tools, among many others, is a deposition. And so the first purpose of a deposition is to find out what the other side has, to find out what the information is. And you can find out that information in order to make decisions about settling the case, or decisions about how much to offer, or prepare you to actually try the case. So the first thing that we do whenever we're looking at the purpose of a deposition is look at the actual rule. And the rule is we're doing depositions to find information. The second purpose of a deposition is to size up the other side. One of the most important things in determining what a case is worth or how a case should settle is how credible the witnesses, or likable even, the witnesses for the other side are going to be. And one way you can find that out is to take their deposition and ask their questions and then find out about them. The third thing that people are trying to do in a deposition is to lay traps. And by laying traps is to get somebody to say something under oath that can be used later on in a trial of a case. The 2 main traps that people fall into during a deposition is to lie about something, which is the most devastating thing you can do in a deposition, is to lie. And the second thing is to agree to something that you shouldn't have agreed to. Something that's not a lie, but something you just should not have conceded. Now, the final thing that people use depositions for, in addition to getting information and laying traps, is to intimidate the other side. Depositions are sometimes done just as a matter of making it painful for the other side, for them to think that they want to settle. And unfortunately, I've seen many long depositions that as a result of the deposition at the end, the person says, I just don't want to go through that again. And so here's what I would tell you is that when we look at the purposes of a deposition, we also want to look at what the purposes of the deposition is not. A deposition is not about telling your story. It is not about being heard. It's not about having the other side know what your feelings are about a matter. It's certainly not a matter of making sure that the other side knows about each and every fact and every opinion that you've ever had about your case. Depositions are defensive in nature. No one ever wins anything in a deposition. The best result you can have when you had your deposition taken is to not lose ground or get hurt. So what you want to do or be able to say at the end of a deposition is that they didn't lay a glove on me, not that I convinced anybody of anything. So again, the purpose of the deposition is not to convince the other side of anything, and it's certainly not to impress or convince the other lawyer of the rightness of your cause. even if something you said during the deposition actually made a dent in how the lawyer thought about your case, they are not going to let on. So let's go back and look at the 3 rules and see how they apply to the purposes of a deposition. So the first rule is tell the truth. Now, that seems so obvious. Of course I'm going to tell the truth. I'm under oath. A judge has told me to tell the truth. Now, what I will tell you, though, however, is that people who are very honest people in every other aspect of their lives will end up lying during depositions. And the reason they will lie during a deposition is a lawyer will ask them a question in such a way that it seems like the truth hurts them or is embarrassing or will make them look bad. And what I will tell you is the truth will set you free. The truth is always a better answer. An example is if someone is handing someone a document, and they'll say to the witness, did you sign this document? And they look down there and they see their signature at the bottom of the page. And they say, well, did you read this document? Now, there are situations where people sign things that they have not read, but it's a little embarrassing to say, I haven't read something, but I signed it. And so you may have someone who says, yes, I signed it, and no, I didn't read it. You didn't even look at it? Well, I guess I looked at it. Well, I had to look at it in order to sign it. How long did you look at it? Well, I don't know. Did you look at it for an hour or 3 hours? Well, no, not that long. 1 second? Well, no, it had to be more than a second in order for me to sign it. 5 minutes? Yeah, 5 minutes. That sounds right. So all of a sudden, the person has been nailed down to saying they looked at a document for 5 minutes, when in fact they really didn't read it. And at that point, the lawyer can take that document, put on a stopwatch, and show you that you can read the entire document in 5 minutes. So people get in situations where they feel uncomfortable, they're afraid of looking bad, and they don't tell the truth, when the truth actually would be better for them. So rule number 1, tell the truth. You can fix almost everything else, but if you don't tell the truth, then you can be guaranteed that you're going to hear about it later in the trial or in settlement negotiations. The second rule is telling the truth does not mean telling everything you know. Now, when I was a kid, my mother would say this to me, and what she meant by that was that I was talking too much. And I was a talkative kid. You know, comes in handy when you're a lawyer later. But it's a very important rule. Telling the truth does not mean telling everything you know. So remember, the purposes of a deposition is for the other side to try to get information from you. And you will hear from every lawyer say, only answer the question asked. Don't volunteer information. So when the other side gets information from you, then they get an advantage. So you want to tell the truth, but if they don't ask you a question about something, don't volunteer that information. If they do ask you a specific question about a specific matter, you should answer that truthfully and honestly. But many people feel like it's important for them to tell their whole story. But if you think about it, it takes more time to tell the story of your life or your lawsuit than to live the facts that are involved in your lawsuit. And so you are necessarily going to leave things out. One of the things that's interesting too is that the more you talk, there is more to pick at. And the longer your deposition will get stretched out. And the longer the deposition goes, the more likely it is that you're going to make mistakes. Mistakes such as agreeing to things that you shouldn't agree to or to lying. So rule number 2, telling the truth doesn't mean telling everything you know is important on all aspects. Now the final rule is telling the truth doesn't mean telling everything you think, which is distinct from telling everything you know, because there are things that are factual that you know, but then there are opinions that you may have about things. For the most part, unless you are asked a specific question about a specific issue. Do not give opinions. I'm going to give you an example. It's a fairly extreme example, but I was working with someone one time to prepare them to testify in their divorce case. I just easily asked, tell me about your husband. And the client said, my husband is evil and crazy, and it would be better off for my children if he were dead. And I said to our client, never say that again. And she says to me, but you told me to tell the truth. And I responded, no, that's not the truth. That's something you're making up. Now, what was true is that he was probably unfaithful and he spent money in different ways that he shouldn't have spent money. But evil and crazy is an opinion, and it's an opinion that she needed to keep to herself. So that's an extreme example of someone giving an opinion of something that they thought. But my favorite bumper sticker right now is don't believe everything you think. If during your deposition you follow these rules, that you tell the truth, telling the truth doesn't mean everything you know, and then finally, and most importantly, telling the truth doesn't mean telling everything you think, you won't necessarily win your case during your deposition, but you won't hurt yourself either. And that's how you win.